Their Lordship, as a tradition of this bar, the President always stands for the first time to extend the New Year greetings.
Oh, thank you so much.
So therefore, on behalf of the entire bar and on my own behalf, I wishes Happy New Year to my lords,
Thank you.
with a
Thank you so
belief
much.
that the start of the day of the year mark with a milestone, with a clarity of justice, with a clarity of mind, and continued wisdom in upholding the rule of law. Once again, my lord,
Thank you.
we at the bar wishes a happy New Year with a prayer to the Almighty God. May they shower their choicest blessing of good health and a prosperous Happy New Year, my lord. I will be joined by the Learned Advocate General on behalf of the state.
Thank you so much. Happy
Very-
New Year to you all.
Thank you.
Very happy
From our
New Year to
side
your
also.
lordships.
Like,
Thank you so much. And wish you all the best for the upcoming new year
thank you, my lord.
and many more years to come. And wisdom will always require.
May I Lordship?
Yep.
I beg to mention item number 5.
Okay.
On behalf of M. Biswas, he is from Guwahati. This matter, kindly matter may be fixed on 23rd January.
30 January, 20 January,
23rd, 23.
23 of January.
Lordship, in this matter, Lordship, Learned AG will be appearing for the state, Lordship. The matter may fix on 9th of February, Lordship.
Okay, 9th of February.
Yes, Lordship.
9th of February.
Learned Council, Mr.
B. Sivo on behalf of M.
B.
Biswas.
Sibok on behalf of Learned Council, Mr. L.
M. Biswas, behalf of
Council, Mr. M. Biswas has prayed for adjournment. Learned Council, Mr. Learned Government Advocate, no?
Close.
Government Advocate,
Close.
Mr. once more.
Yes, Tapin, Lordship.
S. Tapin is present. List this matter on 9 February.
9th February, Lordship. Problem.
Oh,
Item number 1 and 2.
May I plead, my lord?
Mm.
My lord, I am appearing for the petitioner in item number 1.
Mm.
Here, my lord, the petitioner want to engage some other advocate.
Okay.
So matter may be adjourned for today. I have communicated the same to my.
There is an act under challenge. That is why I am appearing. Let this also be fixed on 9th of February.
9,
Since the
all at the
other-
same time. Okay. Learned Council, Mr.
N. Tajan, petition
N.
Tajay.
Tajin on behalf of Learned Council, Mr.
No, my lord, I am,
Okay. Learned Council, Mr. N. Tajin has submitted that the petitioner
yes,
is willing to engage another advocate
yes.
and has prayed for adjournment. Learned double AG, no?
Advocate General.
Learned, sorry, very sorry.
No problem.
Learned Advocate General, Mr. I. Chaudhary, because you look so young, that is why. I. Chaudhary is present for the state of Arunachal Pradesh. List this matter on 9 February.
9th.
All right.
Lordship, I am for item number 2.
That is a connected matter. So that
Connected. Okay.
item
same-
number 2 is connected.
Okay. Connected, but advocate is,
Advocates are-
Different advocate.
nobody wants to change the advocate, no?
No.
Okay.
Same
The item number 2, likhi diya. Learned Council, Mr.
On behalf of Arsonar,
What is your name?
M. Khambo.
On behalf of Learned Council, Mr. R. Sonar
Yes.
is present, and the Learned Advocate General, Mr. I. Chaudhary is present for the state of Arunachal Pradesh. This matter on 9 February.
Right.
Item number 3 and 4.
Wish you, my lord, happy new year, sir.
Thank you so much.
My lord, item number 2 and 3, my lord.
Ah.
3 and 4. Of course, my lord, matter was fixed today as per the convenience of my brother, my lord, Advocate General.
Mm.
My lord, I had the impression that I talked about the item, my lord, inquired about Mr. Takun. And he has, my lord, just intimated me that may not be possible.
Mm.
So, my lord, in fact, my lord, I am very sorry that I could not bring all the brief, my lord, from the hotel. I had my impression that possibly matter would not be taken up.
Okay.
So, my lord, otherwise, my lord, matter has come for admission. And we have challenged by filing this writ appeal,
Hmm.
my lord, against the judgment passed by single judge.
Hmm.
So my prayer is that, my lord, since it is a, my lord, writ appeal, so matter may be admitted. And matter may be fix a date according to convenience of my friend, my lord, Advocate General, respected Advocate General, and matter may be heard, my lord.
Any objection?
So far as the admission is concerned, any other date I have no problem. So far as the admission is concerned, my lord, this is not a matter to be,
Lot of problems.
not a matter to be even admitted. Therefore,
No, it is his argument, my lord. But my lord, none of the, my lord, submission what we have made, my lord, whatever written argument we have made, nothing was considered, and the plea they have taken, none of the plea is sustainable in law. Because my lord, each and every argument is supposed to be, my lord, supported by my lord, decision of Supreme Court. Nothing was considered, only reference of some judgment. They took the stand policy decision, they took the stand financial crisis, they took the stand, my lord, of false affidavit. They took the stand, my lord, ultimately, my lord, it was amended by the government. So, my lord, a lot of things are to be argued. So unless and until matter is admitted, and it is for the court whether matter to be admitted or not admitted. And I have nothing to say, my lord, so far as the submission made by Advocate General. So, my lord, my prayer is that matter may
for
be
admission, my lord, your lordships will have to hear whether
Yes.
there is any merit for admission.
Definitely.
That's right.
Definitely will hear you out. It's item number 4.
Item 3 and 4.
3 and 4
Four are
connected, man.
analogous
Right.
matters, okay. Learned Counsel Mr. A.K. Prakash is present for the, these are appeals, no?
Wait a minute.
Present for the appellant. Learned Advocate General Mr. I. Chaudhary is present. A prayer for adjournment has been made on behalf of, for the appellant, on behalf of the appellant. Place this matter on same date, 9 February?
Can it be on 20? Because 9th already 2-3 matters
Yes,
have been
yes.
fixed. Can it
20th,
23rd of February?
23rd of February.
Hmm.
Is it okay, 23rd of
Yes, ma'am.
February?
My lord.
All
No,
right.
I'm very sorry, my lord, for inconvenience.
This is a new matter, it's okay, 23rd,
Mal.
no problem as such,
Obliged.
23rd February.
Obliged.
Over? One people tell you.
May I please?
Yes, yes.
My lord, I seek to post this matter for withdrawal.
Hmm.
This is unlisted.
Okay,
This matter may be listed.
Today?
Yes, for withdrawal.
will it be possible today?
If
We'll try,
already
we'll
there.
try.
then we can do it.
Yeah, my lord.
Hmm.
Item number 7, my lord.
7,
Yes, my lord. Here I have to file my affidavit in reply, my lord. I am for a petitioner.
for the petitioner?
Yes, ma'am.
Okay, you will file affidavit in
7.
reply.
Yes. ma'am.
Learned Counsel Mr. J. Ginny,
B. Picha, my lord.
Learned Counsel Mr. B. Picha has prayed for adjournment to, has prayed for time to file affidavit in reply.
Reply. Yes, my lord.
You have taken consent from the other side?
He is not present, my lord.
Okay. List this matter,
After 4 weeks, my lord.
list this matter after 4 weeks.
My lord. Obliged, my lord.
All right.
Obliged.
Lordship, I would like to mention item number 15 on
Mm.
behalf of L. Perme, Standing Council for Agriculture.
Item number 15,
Yes. Here, affidavit is yet to be filed, Lordship.
okay.
4 weeks time maybe.
You for the petitioner,
For respondent number 1 and 2,
Learned Counsel Mr.
S. Yirang on behalf of L.
S.
Perme.
S.
S. Yirang,
Irang. On behalf of Learned Counsel Mr. S. Parme,
L. Perme.
L. Parme has
Standing
prayed for
Counsel for
adjournment to file affidavit in opposition.
Affidavit, Lordship. No, yes.
Affidavit in opposition for respondent number
1 and 2, Lordship.
1 and 2. Have you taken consent from this?
Yes, I have taken consent
Full
from the
stop.
petition.
Consent has also been taken from the other side. List this matter. When do you want?
After 4 weeks, Lordship.
After 4 weeks.
1 time. I leave next.
Yeah, Your Lordship, I beg to mention item 11. I'm
Okay.
appearing with the Pangi.
Hmm?
I beg to mention item number 11.
Yes.
I'm appearing with the Pangi.
Oh.
In this matter, we need some time to file rejoinder.
File,
Rejoinder.
rejoinder. Learned Counsel, it is
11 vote.
prayed on behalf of Learned Counsel Mr. D. Panging for the petitioner for time, to allow time to file rejoinder.
Yes.
Full stop consent has also been taken?
Yes,
The other
Lord.
side?
Yes. Yes, Lordship, I've
Okay.
taken consent
Is this matter, when do you want?
after 3 weeks.
After 3 weeks, okay?
Of Lordship.
My lord, I beg to mention item number 6, my lord. Dear my lord, Paraways comment I have not yet received from the department, my lord. Can this matter be released after 4 weeks, my lord? Item number 6, my lord.
Item number 6, you have
Yeah.
not received Fairways comment
Yes,
from
my
the
lord.
department.
My lord, that's,
You are for education.
yes, my lord, standing
Learned
counsel.
Mr. Titagum,
Yes, my lord.
for education department has submitted that he has not yet received Fairways comment from the department and has just prayed for adjournment. Full stop consent has also been taken
Yes,
from the other side?
I am for the petitioner.
Okay. Your name?
S. Sharma.
Full stop learned counsel, Mr. S.
Sharma.
Sarma is present for the petitioner. List this matter after 2, 3,
4 weeks, my lord.
4 weeks.
Your lordship, interim order is there.
Interim order shall remain in force till the next date of listing.
Obliged.
Your Honor, I beg to mention item number 17. The standing council is out of station. Moreover, we have to file this matter, affidavit in this matter.
It is submitted on behalf of learned counsel, Mr. S. Mao,
As more,
that he is out of station. Your name?
Tapi Nuki,
So,
Tinguki,
learned counsel, Mr. Tapi
Nuki.
Nuki is present for the applicant. Full stop, have you taken consent from the other, oh no, the consent is not required, okay. Who is present here for, you are present on,
None.
for the government?
Yeah.
It's okay, it's,
22nd. 22nd.
Or less, no, 17.
when do you want?
22nd. 22nd.
22nd? February,
The-
January?
The
January.
February last week,
January 22nd.
22nd.
Okay. Please just met on 27th January, all right?
Oh.
My pleasure, lordship.
Mm.
I'd like to mention item number 4. It may be posted day after tomorrow.
Item number 4, day after
Yes,
tomorrow.
yes, day after tomorrow.
Your name?
Lordship, I'm appearing on behalf of R.L. Tungan, Rinchin Ledo Tungan.
Okay.
The telephonic instruction from my
Legend.
friend.
Been sought on behalf of learned counsel, Mr. R.L. Tungong, representing the petitioner. List this matter on day after tomorrow?
7th. On 7th.
7th. Day after tomorrow, 7, no?
7th.
Okay.
Highly obliged.
May I please, your lordship?
Mm.
Lordship, I beg to mention item number 14, your lordship.
Mm.
In this matter, your lordship, we are yet to receive our Fairways comment, your lordship. Therefore, your lordship.
Fairways
kindly-
comment.
Yes. Kindly post this matter after 3 weeks, your lordship.
Learned counsel, your name?
P. Sangeeta.
P. Sangita. Learned counsel, Miss P. Sangita on behalf of?
Official respondent, your lordship. Government advocate. your lordship.
Okay, government advocate, learned government advocate, Miss P. Sangita, has prayed for adjournment,
Yes.
on behalf of the respondents.
Yes.
As they have, as, Fairways comment is yet to be received from the department.
Yes, your lordship.
Who is present for petitioner?
I have taken consent
Course of consent has already been taken from the petitioner. List this matter when you are.
after 3 weeks, your lordship.
List this matter after 3 weeks.
Obliged.
May I, Lordship?
Mm.
Lordship, I beg to mention item number 8
Okay.
on behalf of M. Kato for respondent number 1, 2, 3, and 4.
Okay, adjournment.
Yes, Lordship.
Adjournment has been sought on behalf of learned counsel, learned DSGI,
Yes, Lordship.
Mr. M. Kato. Anybody, your consent has been
Yes,
taken?
Lordship.
Yes, I'm the petitioner.
You want your presence to be recorded?
Yes, your lordship. I'm for respondent number 5, 6, 7, and 8, your lordship.
Okay, learned counsel means what for your name?
P. Pangu, your lordship.
P. Pangu, Pangu, no?
Yes, Pangu.
P. Pangu is present for respondent number 5,
6, 7, and 8.
5, 6, 7, and 8. Full stop. Consent has also been taken from the other side. Okay.
Yes.
List this matter. When did you say?
Lordship, 3 weeks, after 3 weeks.
Release this matter after 3 weeks. Okay.
And Lordship, another matter,
Mm.
I beg to mention, item 10.
10. Okay.
Yes, Lordship.
Adjournment has been sought on behalf of learned counsel, learned DSGI,
Yes, Lordship.
Mr. M. Kato. Full stop. Consent has been taken from the other side. Okay.
Yes.
List this matter when you want.
Lordship, after 4 weeks, we
After
will
4
file
weeks.
affidavit here.
Lordship, that interim is there, that may be continued.
Interim order shall remain in force till the next date of listing.
Obliged.
Lordship, further I beg to mention another item.
Okay, why not?
Item 19 and 20.
19 and 20.
Yes, Lordship.
For M. Kato, no? He's
Yes.
out of station.
Yes, Lordship, he is out.
Adjournment has been sought on behalf of learned DSGI Mr. M. Kato. Full stop. Consent has also been taken from the other side.
Yes, Lordship.
List this matter when you want.
After 3 weeks,
After
Lordship.
3 weeks.
Obliged, Lordship.
Item number 1.
Yes.
Yes, Lordship, this matter is application for initiation of contempt proceeding for willful violation of order dated 7 and 2025 in writ petition port 55 of 2024.
Will issue notice?
Yes, Lordship.
Your name?
S. Irang, Lordship.
S.
S. Irang.
Irang, no?
Yes.
Learned Counsel Mr. S. Irang is present for Learned Counsel Mr. L. Parme.
Yes, Lordship.
Okay?
Yes.
Oh, your name is in the cause
Yes,
list?
my name is Nako.
Oh, it's not required then?
Yes.
We'll mention your name. Okay, Learned Counsel Mr. S. Irang, that much will be sufficient. He is present. Issue for the petitioners, issue notice to the respondents. List this matter on, when do you want? 4 weeks?
Yes, Lordship.
This is the first case of this year?
Yes.
Huh? 2026? 1/2026. First case of this year. List this matter after 4 weeks.
Item number 2.
Well, the question involved in this writ petition is that the Panchayati Raj election, my lord, disaware, was held. Then what had happened, the petitioner was elected unopposed. Then thereafter, there is a complaint against the petitioner that he has used the fraudulent means and all. So law is well settled, my lord, that any dispute, because you have scrutinized the nominations, published the ballot list of the candidates, and then you have given me the form elected unopposed form 21 and the 25. So thereafter, my lord, all the disputes lies before the election tribunal, not by means of suspending. The ADC has acted beyond the jurisdiction, violating the mandate of Article 243(o). So therefore, as a returning officer, he is not supposed to do. He has overstayed. So, my lord, the discrepancy is, my lord, will kindly come to page 20 straight.
Panchayat elections.
Panchayat elections, my lord.
So this comes to the High Court state. It doesn't go to the district judge.
No, it will go. It will go, but here, the once you are given form 25, in terms of Rule 60 of the Panchayati Raj conduct of election rules, then the role of the returning officer become functus officio. Perform the duty, and then your office also goes off by that way, my lord. So here, my lord, will kindly come. I'll take 5-10 minutes, my lord, to clarify, because I am praying for the interim order, because you do not have the
Looks
jurisdiction.
like you're praying for interim order. Okay.
Yes, sir. So, my lord, will kindly come to page 20 at the moment.
Page 20.
Lordship, I have a prayer, Lordship. I'll come with instruction, Lordship. Instruction will be required. So matter may fix on 8, Lordship, after 2 days.
No, my lord, there is something. Brother, please accommodate me.
On
Because
7?
I'll place
On
my-
7?
On 7, day after tomorrow may not be possible. On 8, that's Thursday.
No, my lord, the reason is on 10th.
Because still for
No,
2
no.
days, I think interim may not be required, Lordship.
No, my lord, there is a reason why I am insisting. But that's why advance copy is served to my brother. And then if
No,
my...
I don't see any reason, because you are already elected and you are
No, my lord.
the chair.
No, my lord.
No. Okay.
I have been suspended by the returning officer without jurisdiction, my lord. Then they kindly see, my lord, I will place the fact, and then I am placing a judgment, because there is a judgment by our High Court itself that once you are declared elected unopposed and Form 25 is given, read with Rule 60 of the Conduct of Panchayati Raj elections in Arunachal Pradesh, then the role of the returning officer comes
Get
to
the book first.
my lord,
Panchayati Raj.
I'll give everything, my lord. I'll give everything.
No, we have our own books also.
Yes, my lord. There is a judgment by our High Court. You cannot suspend. You cannot overstep the mandate of Article 243, my lord.
Okay, let's see.
Yes. Nalinda. I have printed extra copy also if it is not here.
Okay.
See, my lord, kindly
Where is the impugned order?
impugn order, my lord, we'll see at annexure annexure 8, my lord, page 47. You have the copy here. I'll give it. Page 47, my lord, is the impugned copy. The type copy is at 48 for clarity, my lord.
Okay. All right.
Yeah. A complaint was recorded at ADC stroke returning officer Percy Perley on 16/12/2025 from Sri Sangha Tasong and Sri Sangha Boy alleging that the nomination process of Srimati Sangha Anyam, wife of Sri Mangyo Taruk against 6/2/2/1 Mangyo 1 segment Sangha Gram Panchayat falling under 6 Parsi Parlo JP was flawed and that Srimati Sangha Anyam impersonated in the name of, my lord will mark this impersonated, I'll clarify this, impersonated in the name of Sangha Anyam, daughter of Sangha Tasuk late at serial number 77 and was elected unopposed. In this regard, the BLO stroke GB stroke polling agent along with concerned reputed local leaders were summoned and have furnished a statement attesting to the same and to the fact that Sri Sangha Anyam, daughter of Sangha Tasuk late, and Srimati Sangha Anyam, wife of Sri Mangyo Taruk, are two different persons. On the day of poll, 15/12/2025, the voting rights were exercised by Srimati Sangha Anyam, daughter of Sangha Tasuk late, not by Srimati Sangha Anyam. Thus, in accordance with, my lord, we'll mark this. Thus, in accordance with Section 120 of 120 subsection 1A of the Arunachal Pradesh Panchayati Raj Manual Acts and Rules 2025, the certificate of the election for uncontested GPM issued to Srimati Sangha Anyam is kept in abeyance till further orders.
Okay.
Now, my lord, without wasting any time, I'll come to the authorities straight if my lord feels so. I'll come to the straight to the authorities. When that Guwahati High Court. You have the extra copy. Yes, I can give to Tapi. Tapi, you can also have this. Yeah. Madam, please. It's all right. I have. Even this is 1999. 2009 also we have the judgment, my lord. This was a case from Manipur, my lord, the case from Manipur. And then instead of filing election petition, a civil suit was instituted and application under Order 39 Rule 1 was filed. So then the court interfered. No, anything, if a person has been declared elected by the returning officer, then the remedy lies before the tribunal only. That is district court, my lord. So that's kindly come to para 5. That is the fact of the case. Para 5, my lord. It is true that where an act confers a jurisdiction, it impliedly also grants the power of doing all such acts or employing such means are essentially necessary to its execution. At this stage, I hereby recall the legal maxim, namely, Jurisdicio data est ia kyoku concessia esse vendinator sin ni cubas jurisdictio explicare non-protest, meaning thereby to whomsoever a jurisdiction is given, those things also are supposed to be granted, without which the jurisdiction cannot be exercised. The grant of jurisdiction implies the grant of power, grant of all powers necessary to its exercise. Here, in the instant case, the election tribunal can deal with election dispute and any other election matters by borrowing or applying the required procedure available to the Code of Civil Procedure while dealing with an election petition. And it should be noted that the word procedure shall never be interpreted, and it shall also cannot make the inclusion of power or provisions which are not specifically conferred upon the tribunal under the related acts rule as discussed above. The power for grant of temporary injunctions or not to grant of it are not essentially necessary while deciding an election petition on its merit, in as much as such power of inherent power are not provided in the related acts and the rules, and over the above this, the election tribunal do not possess common law power, and that grant of those powers as discussed above are not necessary to do its exercise or its execution. Now 6 and 7 is very important, Lord. These are the fact. The Manipur Panchayat Raj Acts and Rules provides for only one remedy, that being an election petition to be presented at after the election is over. As such, there is no remedy provided at any intermediate stage. In this regard, a reference can be made to a decision of Apex Court rendered in NP Ponuswamy appellant versus returning officer Namaklal and others respondent reported in AIR 1952 SC 64, wherein the Apex Court held thus. It is now well recognized that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by the statute only must be availed of. This rule was stated with great clarity to Willis J. in Wolverhampton New Water Works Company versus Hawksford, 1859, 6, so and so in the following paragraph. My lord, I skip this. Para 7, my lord. There's everything is there. Para 7 is most important, my lord. Inherent powers are of a court, and election tribunal is not a court as they created by statute to decide certain disputes and are bound to decide them strictly according to law after following the prescribed procedure, and have jurisdiction to do only that they are expressly empowered to do. Only those courts which have general jurisdiction to do justice under the common law are competent to pass any order that have considered necessary in the interest of justice, even though they are not covered by express provision of law of procedure by invoking inherent powers, including reference has already been made to the decision of the Apex Court reported in so and so, and which explains the nature of election tribunal. In my consider opinion, it will be proper exercise of discretion by the High Court, either under 226 or 27 of the Constitution of India, to determine the interference with the impugn order, as the order is not an order passed by election tribunal. Here, my lord, the returning officer, my lord, has become functus officio. He do not have. Say, this will, my lord, fortify my argument. Kindly have this, my lord. Rule 11. 2001 Rule 11, my lord. I'll explain this procedure and then I'll come to Rule 16. Huh. No, I have the copy. This Lordship's ka rule likha lo. No, page, there's the page.
Same book.
Same book. Same
Page.
book. Page, my lord, just I'm giving it. Page, my lord, kindly come to page. 1 second, I'll start from Rule 11 only.
Okay, I got
But
the
page, but kindly see page 83.
It's not page 83 here, it will be after 94.
94.
2001 rules, no?
2001 rules. Okay. Now, kindly see
2001? No,
conduct of election rules. Nalin.
no.
Well, it is 81 only.
81, no?
80, 88, yes. It will start from my lord 83, my lord, according to my.
Not in this book. I'll just check the index.
My lord, I'll help. Starting
I
from
got it, I got it. From page 94 only. In this book, it is from page 94.
Okay, hour is something. Okay, madam. Fine.
Rule 11.
Rule 11, kindly see. Now, how the process starts, my lord. Well,
Yes.
notice of nomination and time and place for scrutiny, my lord. He does in Rule 11. Then Rule 12, my lord, kindly see. Rule 12 is scrutiny of nomination, my lord.
Yes.
My lord will see at the right side.
Yes.
There is a heading. Now, Rule 13, my lord, kindly see. List of validly nominated candidate. This also he has complied it. Then Rule 14, my lord. Withdrawal of nomination, notice of withdrawal of candidature. My lord, kindly see Rule 14. This is also complied.
Okay.
Now, kindly see, my lord. 15, preparation of list of contesting candidates. This also the returning officer have done it. I'm nulling up. Now, kindly see, my lord, Rule 16, my lord. Publication of list of contesting candidates. Right. Then my lord will see at page 36A in my read petition. 36A. Final publication, my lord. In my read petition, my lord. Page 36A. I stand
Page 36A of the petition.
petition, my lord. Serial number 35, my lord.
36A.
36A, my lord. Bottom, kindly come to bottom.
Yes.
Kindly come to serial number 35, my lord. Reserve.
Serial number 35.
35. Srimati Sangha Anyam. Sangha Roruk. So and so. I'm contesting from the PPM. Now, in my case, my lord, kindly come. Then kindly come to section Rule 22, my lord. Here, 19 will not be applicable in my case because I am uncontested. Procedure in contested and uncontested. 22 is important, my lord.
Page rule number 22, yes.
Yes. Kindly see, my lord. Procedure in contested and uncontested elections, my lord. Here, if at any election to a Gram Panchayat or Jila Parishad, A, the number of contesting candidate is more than the number of seats to be filled, a poll shall be taken. B, the number of such candidate is equal to the number of seats to be filled. The returning officer shall forthwith declare in Form 14 all such candidate to be duly elected to fill those seats. C, the number of such candidate is less than the number of seats to be filled. The returning officer shall forthwith declare in Form 14 all such candidate to be elected and inform the district election officer, state election commission, and government for taking appropriate. C is applicable in my case. May Lord kindly come to page 37. हाँ, ये वाला ना, तो देखा. Annexure 4, 37.
Yes.
37 of the read petition.
Yes.
Certificate, Rule 64. Hereby certify that I have a returning officer, so and so do hereby certify that I have on the 29th day of November 2025 declared Srimati Sangha Anyam of the village Mangyo OPS Percy Parlo to have been duly elected GPM from so and so Mangyo constituency, my lord. Now done. So this is exactly done, my lord. Kindly come to Rule 60.
Rule
60.
60. Yes.
Now, my lord, rule 60 only, I'll just reference only. Right, my lord, there is a subtitle, declaration of results of election and return of election, my lord. That much? This is exactly complied. This rule is complied. Now, my lord, what is the procedure given thereafter? Once a person is elected, the election procedure has come to an end. So therefore, the role of the returning officer has become functus officio. Now, but kindly come to, my lord, rule 69, my lord. जजमेंट को कहा नहीं सुप्रीम कोर्ट गई हम तुमको भेजा था ना व्हाट्सएप हाँ सुप्रीम कोर्ट को now my lord see 68 my lord will read procedure of declaration of the result first now my lord kindly see all this process is over now result is declared elected unopposed
Yes.
then my lord rule 68c when the counting of the vote is completed, the officer appointed by the Deputy Commissioner shall to be elected in Form 26, the candidate in whose favor the largest number of votes were cast.
Rule 68?
Yes, Rule 68, my lord.
Okay, yes.
Now, my lord, 69 is important in my case. Election disputes, my lord, part 7. The part 7 says, the petition referred to clause A, subclause Roman 1 of subsection 3 of section 122 shall be filed before the election tribunal within 30 days from date of declaration of the election results. Now, my lord, kindly see, you are bound to follow the procedure established by the law. Because in any election dispute, my lord, under Article 243, there is an explicit bar. Similarly, read with Article 324 of the Constitution of India, where State Election Commission is also there, right? The Union Election Commission. Same thing, Election Commission of India. There is a bar, my lord. You cannot agitate. So therefore, my lord, under 226, my lord, law is well settled that any electoral disputes during the electioneering process, the read court is barred from entertaining. But there is an explicit bar, even by our act itself, my lord. Our act also, the Panchayati Raj Act also, just that section C, just see the section. Any election
barred from interfering.
Yes.
So you have filed a writ petition here.
This is for the reasons because a person who has ceased to be the officer, sees his power, he do not have the power to issue this, except person who is aggrieved has to file a election petition
Election
before
tribunal.
a tribunal. Not by this means of, you do not have the power to suspend or kept against my election. You cannot. Huh? 243, or that I have referred to. Now, my lord, kindly see this. It's very painful to see this. This is not correct, my lord. And my lord, where the I'll come. Sir.
Yes.
Have you given this 1985 for SSC? I have given you this. My lord, just I read this judgment.
1985 4 SSC.
1985 for SSC, page 194. It's a very 3-page.
Okay.
Para 4 and 5. 4. I
Page
will.
184.
Yes. Not 194.
194.
185 for SSC, 194. Para 4 and 5, my lord.
Party's name?
Party's name is, my lord, Krishna Balla.
Okay.
Krishna Ballabh Prasad Singh versus Sub-Divisional Officer, Hilsa, come returning officer and others.
SDO.
SDO.
SDO, which place?
SDO Hilsa,
Hmm.
come, returning officer and others. My lord, I'll just print it and give it.
Okay,
my lord.
okay.
Huh. My lord, kindly see, in this is a small judgment by the apex court has been time and again very clear, my lord.
Hmm.
The process of election, my lord, says this, we have read the rules. Now, up to Rule 69, we have read. See, if there is anything, you have to prefer an election petition before the tribunal. But the returning officer, once the election process is over, his power is seized. So therefore, you cannot issue this order. This is what the main grievances in this case. I read this. The process of election set forth in the Representation of the People Act 1951 consists of the several stages, and towards the end, it requires a declaration of result of election. Section 66, here, my lord, that's section 60, my lord, has seen. Section 66 of the Act provides that when the counting of votes has been completed, the returning officer must declare forthwith the results of the election in the manner provided in this Act, or the rules made thereunder. Thereafter, under Section 67, the results of the election is reported by the returning officer to the authorities specified therein, and declaration is published to the official gazette. It may be mentioned that according to Section 67A of the Act, the date on which the candidate is declared by the returning officer under Section 66 to be elected is regarded as the date of election of that candidate. So my lord has seen that election 3, I have already been declared, election 4 also. Thereafter, the procedure for declaring the results of the election is set forth in the Rule 64 of the Conduct of Election Rules 1961, Rule 64, the Form 1, Form D, this declaration is there. So now, my lord, I'll read paragraph 5. I'll give this. We are of the opinion that the process of election come to an end. Here the question of functus officer comes. We are of the opinion that the process of election came to an end only after the declaration in Form 21C was made and the consequential formalities were completed. The bar of Clause B of the Article 329 of the Constitution came into operation only thereafter, and an election petition alone was maintainable. The read petition cannot be entertained. The law is settled, my lord. Now, returning officer, that he has already become a functus officio, therefore, he cannot do this, my lord. So, therefore, my lord, now I have to clarify this two thing, my lord. Now, my lord, how this impugn order was issued, my lord. Kindly see.
On the basis of a complaint?
On the basis of the complaint. Complaint, my lord, on 18. My lord, kindly come, page 45. No. My lord, 41.
Page 41.
It's 41.
Yes.
Now, my lord, this is the complaint which they have given on 16/12, and my lord, on 18/12, 18/12, kindly see, my lord, the copy of this complaint was forwarded to the district election officer, PR, that is Deputy Commissioner Kurungkome, my lord. Now, on 18/12/2025, my lord, this complaint was forwarded to the DC by the returning officer, but no notice was given to me, my lord. Because you are going to affect my civil right very seriously. Once I have a fortified civil rights under the law, you cannot overtake it. Well, that Mohinder Singh Gill judgment, I am going to place this on the audio alter and palter, because it is a must you have to give me. So then, my lord, kindly see on 19, next day, my lord, very next day, this impugn order was passed. How dare, under quoting Rule 120, my lord.
When was the order passed?
Order was passed on 19th, 19/12, after my election, my lord. Now, my lord, kindly have this section 120 of the Act.
of the Act.
Act 121, because they have quoted section 120.
Yes, section 120.
Yes, kindly see, a person shall not be disqualified to be chosen to fill a seat in a
Section 120
constituency.
of the Panchayati Raj Act,
Act, my lord,
1997,
1997.
120.
Yeah, 120, my lord, page 27 in my act. I
No,
think that is something.
Not based on here, it will be 30. It will be 121, I think.
120, my lord.
A person shall not be qualified to be chosen to fill a seat.
That is amended one. That is amended one. Second. This is amended. This is amended, my lord.
Yours is amended.
Yeah. Anyway, my lord,
Mine
say-
is old, last amended on
2019.
this 2018.
The 18. Oh, okay, we count that 18 only, my lord. But content is same, my lord. My lord, this amendment, why this amendment has taken place? State government in 2018 did not conduct the panchayat election after expiry of the tenure.
Okay.
Then I filed a PIL, a read petition.
Okay.
I argued against Lesar. I won the case. And thereafter, state government to dispose of all election petition challenging the election to a panchayat. Roman 2, matters relating to disqualification of a member of the panchayat.
Yes.
This comes. But here, without doing this, how a administrative officer who has become functus officio can suspend my election, my lord? Law is not
I
permissible.
think this has happened before here, I think, because all these are marked here in this
Yes.
book.
Yes.
But I haven't in our state, I haven't come across such a situation because as a district judge, I was dealing with all these election tribunal cases.
My lord, Assam, people are civilized, intellect, but so the politicians. Here, it performs in a different way, my lord. Hit and run. They don't follow the rule of law.
There I won't let my comment. But you see, this book is marked.
Yes, yes.
All the rules and act you're referring to,
Yes, ma'am.
sections you're referring to, it's marked here.
Lordship, to read petition, it was during this election.
Same, okay.
During this period, Lordship.
Okay, okay. That's it.
It was already taken up before this whole court. I
Okay.
think therefore earlier Lordship.
It was marked, okay.
Must have Lordship.
Because actually, as a maybe I haven't come across such a petition in the High Court. Maybe my brother judges or sister
It was
judges.
before Lordship Nelson Silo,
Mhm.
and in both the read petition was dismissed by this whole court.
Okay.
Or dismissed.
With observation that Lordship it has to be placed before the tribunal, Lordship.
Okay.
As per the Act, Lordship, tribunal is the Lordship authority, the forum
Yes,
where the election dispute has to be decided.
Yes,
Lordship.
yes, correct.
On that ground, Lordship,
So I think
it was
it's a good
dismissed.
case of stay then. You are agreeing to it then. I think it's a good case of stay then.
There, Lordship, it was dismissed, rather. The read petitions were dismissed.
Dismissed too.
Huh? My lord, fact is different. What my brother Tapin is
No,
proposing.
no, just what I'm surprising this horror court is why it has been marked. Lordship. The matter was taken up before, and this horror court refused to entertain the writ petition because the subject is purely to be educated by the election tribunal, Lordship.
Fine, fine.
So that's just I'm appraising this horror
So,
court.
therefore, my lord, here is a case. My fact is something different, my lord. Because there is a complaint by a third party. Then the complaint was filed on 16/12.
Can we decide it? Then can we remand it? Can we decide and remand it finally at the motion stage?
There is no bar, my lord. My lord.
Therefore, today, Lordship, in the motion stage itself, Lordship, without giving me opportunity to take instruction,
No, you can take
this matter
instruction.
cannot be decided, Lordship, today. Therefore, I was requesting in very limited, Lordship. I may be given 2 days time, Lordship.
Let us give him 2 days time to dispose
No,
it.
but no,
While I'm here.
my lord, there is a reason because I have to file nomination paper for Gram chairperson, lord.
Gram chairperson?
Ah.
Oh, okay.
That is the reason why, my lord, I am from opposition party.
When is the last date?
10th is the last date, my lord. 10 is the election. Tomorrow, 7th, I have to, today, tomorrow. 7, I have to file the nomination paper, my lord.
7th you will have to file.
I have to file in any case. So only.
Tomorrow is a holiday, so
Holiday.
even tomorrow also I cannot take up.
Yes.
Mhm.
So therefore, my lord, only for that count only, well, at least natural justice has to be followed. Number one, the act and statutes clearly provides that once a person has become functus officio, you
So
cannot,
why can you, you cannot write nomination papers?
No, I
Because you are
cannot. I
Already
can-
disqualified,
already suspended. my lord.
suspended in case. You cannot file yours.
Therefore, my lord, this, I was right. I wrote down something about the functus officio, my lord. The meaning, where is this impugn order? I wrote it down this morning. Well, it's a very, my lord, it's difficult to see. Well, just I take out the functus
You
officio.
want the order to be vacated,
No, I want it to be, yes, my lord.
suspended?
Suspended, my lord.
Okay, suspended for the
Yes.
time being.
My lord, kindly see para 12, my lord, of my read petition, my lord. I have nicely described this.
Last date of nomination is
7th.
7th,
7th,
filing nomination.
filing notice. My lord, kindly
Where
see.
12 of your writ petition
Yeah.
is.
That the petitioner respectfully submits that the respondent number 2 had absolutely no jurisdiction to pass the impugn order. The law is well settled that once the returning officer declares the result and issues the certificates of election form 25, he becomes functus officio. He ceases to have any power to review, recall, or suspend the result. In a catena of decision, this proposition of law has been settled by the Honorable Supreme Court, and
You
this.
give me one latest decision, that will be sufficient.
No, but just I'm reading it. Just I'm
But
reading.
you have stated catena of decision, I think one latest decision will be sufficient.
2009 is.
Otherwise, I also don't have time, you see, if you want a quick order,
Yes.
if you give me too many decisions, it will be very difficult.
No, I'm not giving any decisions, my lord. Only reading.
No, I will want a
Yes,
decision here.
Yes.
Because you are talking about functus officio, so I'll need a decision
No,
on this point.
functus officio, my lord, will not find any judgment on this.
No, but here you have said that there are catena of judgments.
No, but this, in this case, the catena of judgment which I have referred to is once a person has demitted office, task has been performed, he demits his office. That is, my lord, there is a word called
It has become functus officio.
co-terminus. Usually we
Yes,
suppose.
the office becomes functus officio, but you have stated, no, there are judgments relating to this returning officer being a functus officio. If you have a judgment, you can.
No, that judgment, my lord, that Siraj Ahmad judgment is clear.
You have given me the.
Yes, I have given. Para 5, 6, and 7.
Okay.
So see, my lord, I have one small judgment also. That judgment also I will place. I'll indicate the paragraph. Just let me see, my lord. In a catena of decision, this proposition of law has been settled by the Honorable Supreme Court, and this Honorable Court, Siraj Ahmad, my lord, stating that the election process culminates with the declaration of results. It is held that the returning officer has no power to alter the results once declared. Once the polls are closed and votes counted and result declared, the returning officer becomes functus officio to the extent that he cannot recall the result. Now, meaning of the functus officio, having performed his office, indicating the end of the power or jurisdiction. But there is one small judgment. Well, that I have read this Krishna Ballabh judgment also.
Yeah.
And I have given that paragraph 5 and 6. It is just, I'm recasting it, my lord. That judgment is fitting into this case. We are, para 5, we are of the opinion that the process of election.
But you have read it.
So therefore, he has no power to do this. And in the act, my lord, this act, we now for a moment, we have to call it as a gospel truth. Because it does not provide the returning officer to recall the order. So therefore, my lord, this impugn order may be stayed. Let's see. And then also, my lord, to an extent, my lord can give a relief to them. the shall be subject to the outcome of this writ petition also for them. However, my lord will put the rider status, then just can also put that rider. Well, I don't want this rider also. But the prima facie illegal.
What is your prayer?
My prayer is to stay this.
Okay.
Stay this because this is an administrative order.
Stay the impugned order.
I don't know what my brother Kafir Samir.
So at this stage, apart from the merit lordship,
Mm,
legality of this order lordship,
mm,
if lordship see the writ petition itself, who is before us lordship, this is one Sangha Anyam.
mm.
See, state lordship, her electoral roll lordship is given
Page 20.
annexure 1 lordship, page 20. Yeah. And finally come to page 21 lordship.
Yes, page 21.
This is the electoral rolls 2025. This is a revised one lordship. And if lordship come to the next page, that is page 22,
Mhm.
serial number 77 lordship.
Okay, serial number 77.
So this is of lordship Mangyo 1 constituency from where lordship the petitioner was declared as a lordship unopposed GPM lordship. Lordship will find here the name is Sangha Yanyam.
Mm,
This is wife of Sangha Tasuk,
mm. Mm.
which is not the same the petitioner lordship. Petitioner claimed that lordship, this is her electoral roll lordship, but at the serial number 77.
That I will demonstrate.
Not the same person.
This is not the same person also.
From which GP?
This is lordship Mangyo segment 6/2/1 lordship.
Okay,
Mangyo 1 segment lordship.
all right.
इसको तो बोलो कम से कम annexure 2 में क्लियर किया है ना सब कुछ
कौन सा?
नहीं इसको तो annexure 2 में क्लियर किया है ना पेपर पब्लिकेशन वगैरह करेक्शन किया हुआ है मतलब this has been corrected from page 26 I'll give the reminder please
Page 26. Lordship, as my friend is insisting to to point out before the lordship how it has been corrected lordship. Lordship, this is the revised electoral rolls of 2025 lordship. Whatever is there lordship, until unless that is corrected lordship, it will remain lordship as it is lordship. It cannot be altered without following the lordship, what procedure has been laid down in the electoral roll process itself lordship, the rules lordship, electoral rolls lordship. If name has to be corrected, age is to be corrected, date has to be corrected as per the provided rules under the act lordship. Rules is given there lordship. Here lordship will find page 26 lordship.
Yes.
Otherwise, anyone can file affidavit and I'll say this is me. If 2%, more than 3, 4, 5% will file an affidavit, particular name is me, then how the authority will decide? What legal point lordship I'm submitting is the lordship. This affidavit cannot substitute the electoral rolls lordship. Electoral rolls can be corrected by filing affidavit if that is lordship permitted under the law lordship. This is the restrictions of electoral rolls.
correction is permissible
Correction is permissible lordship, but until unless
Self-serving affidavit will not.
they cannot substitute the electoral rolls lordship. Otherwise lordship, many affidavits can come lordship. That's a simple question lordship.
everything
Point is that lordship, the electoral rolls cannot be substituted by the affidavit, but electoral roll can be corrected by the affidavit if that is permissible under the rules lordship. That's the point lordship. Now kindly come to the lordship affidavit itself, what it says lordship. Page 26 to series lordship.
Okay.
Lordship, this is I Srimati Sangha Anyam. This her declaration, kindly see it. That I am a citizen of India by birth. That my name is correctly mentioned as Sangha Anyam in the voter ID so and so. That in the electoral roll, my name has been incorrectly entered as Sangha Anyam instead of Sangha Yanyam instead of Sangha Anyam. Both the names refer to one and same person, myself. I am making affidavit correction so and so with the so and so. So this affidavit, until unless this affidavit is recognized by the authority, the registering authority of the electoral rolls, Lordship, it's nothing, Lordship. It must be permitted under the law that by this way of Lordship, affidavit and procedure, Lordship, the name or anything can be corrected, Lordship. If that manner is not followed, Lordship, then Lordship, we can't Lordship substitute by us, Lordship. We can't substitute electoral rolls with the affidavit, Lordship. That's my submission, Lordship. And Lordship, as I submitted, Lordship, I'll not dwell much on the merit. Kindly come to the prayer in the writ petition, Lordship. Yeah, defected. Prayer in the writ petition, Lordship. Prayer number 1, it says, page 16, Lordship.
Yes.
Page 16, Lordship.
Yes.
Prayer number 1, Lordship. A writ in the nature of statutory should not be issued by coercing and setting aside the impugn order so and so passed by the respondent number 2, keeping the petitioner's certificate of election in abeyance. The prayer number 2, a writ in the nature of mandama should not be issued, directing the respondents to immediately allow the petitioner to take oath of office and function as a Gram Panchayat member of constituency number 6/2/1/ of Mengyu 1. I am on Lordship prayer number 2, which is one of the main prayer in the writ petition. Then kindly come to the interim prayer, Lordship. Next page. In the interim, the page 17, Lordship. In the interim, pending disposal of the rule, it is most humbly prayed that your Lordship may be pleased to stay the operations of the impugn order so and so, and direct the respondents to administer the oath to the petitioner pending disposal so and so. The interim prayer and the prayer number 2 is the same, Lordship. And whenever Supreme Court says, Lordship, interim order cannot be granted, which will amount to the final relief, Lordship. What final relief has been sought in the prayer number 2? The same relief has been sought in the interim, Lordship, which is not permissible as per the law.
Which judgment is? There is abandoned. I can abandon it. I'm abandoning that.
No,
prayer.
You know, change your reading as per your will. And
No, my lord, I have full answer.
this is a citation I would like to place before the Supreme Court, Lordship. This is 2005-9 SCC 773, Lordship.
Let us read together.
On the last page, Lordship. On the last page, let me read it.
No, we read together. So that,
I'll read it. You can hear.
no, there might be a jumping of the words also.
No. I'll read the entire paragraph.
Last paragraph, okay.
Last paragraph. On the top, Lordship, not the second last paragraph.
Yes.
To say the least, approach the learned single bench and the division bench is judicially unsustainable and indefensible. The final relief sought for in the writ petition has been granted as an interim measure. There was no reason indicated by the learned single bench as to why the government order so and so was to be ignored. Whether the writ petition was entitled to any relief in the writ petition has to be adjudicated at the time of the final disposal of the writ petition. This court has on numerous occasions observed that the final relief sought for should not be granted at an interim stage. The position is worsened if the interim direction has been passed with stipulations that the applicable government order has to be ignored. Time and again, this court has deprecated the practice of granting interim orders which practically give the principal relief sought in the petition for no better reason than the sought in the petition for no better reason than that of a prima facie case has been made out, without being concerned about the balance of convenience, the public interest and loss of other considerations. Here, Lordship, Honorable Supreme Court says, Lordship, if the public interest, that's the only exceptions carved out by the Honorable Supreme Court.
Where will there be any public interest when the person, that seat is not functioning?
Lordship,
Office is not functioning.
Lordship, the petitioner is before us, Lordship. It's not the PI, Lordship. Public is not before us, Lordship.
Okay,
No,
all right.
no, my lord, I nullify all the argument.
Can I dispose it of finally?
No, my lord. Just, my lord, kindly see, just clarification. One,
Okay, one prayer from your side is that he is not praying for final disposal. He is seeking that suspension till the disposal of this.
So what I'm submitting is the Lordship, that interim cannot be granted, Lordship, which is same as of the final relief.
No.
Lordship. Final,
Till interim suspension till she contests, files a nomination paper and contests, and then we will decide it.
no.
No.
This interim cannot be granted. Interim cannot be granted, which is same. The main relief. I'm not talking about the final relief. The main relief. What the main prayer is sought, Lordship. What I'm submitting is, I'm just, we are getting confused, Lordship.
Actually,
Interim
the
relief.
time is very short.
In,
Maybe the time is very short, and this process before the tribunal, it will take a long time.
And Lordship, kindly say, this impugn order was passed on 19th of December, Lordship. At this belated stage, petitioner has come. Is our part?
This is not belated state. 19th of December, and we are on the first week of January.
But he could have come.
There was a court
Belated in the sense.
During
The
vacation,
reopening, we have,
she or he
please,
come during the
we have to
vacation.
collect it.
No. What I'm submitting is, Lordship, belated in the sense, because day after tomorrow, as submitted, the nomination has to be filed.
Yes.
This is belated for him,
No.
not for us, Lordship.
No, absolutely. My lord,
That cannot be, Lordship, ground, Lordship.
But you see, if I lean towards your submission, then he has one option. He can pray for stay or some postponement of the elections or nomination.
we have filed,
Date
on-
of
this
nomination.
application was filed on 30th December, my lord. It kind of, in between there was a holiday, and then 19th, then our vacation starts on 24. So in the process, the election was on, and then this order was issued. So we collected, we were just having 7 days gap, my lord.
Lordship, this is.
If I lean towards his submission, then you have another option. You can pray for postponement of nomination, date of filing.
No,
nomination
but
papers.
just I clarify everything if my brother Tapin is done.
Lordship, that submission
They-
is not even pleaded in the writ petition, Lordship.
No.
That he want to contest the Lordship, this chairperson.
That is
That is not here, Lordship.
That is not a
But
requirement.
this is
of
a point then.
No, my lord.
That is a point to
He's
ponder.
twisting as per his Lordship convenience.
No. I thought it was in the petition.
No, my lord. I have,
That's a point to ponder.
no, just I made a reference.
Mm.
Anything which I don't plead, I will not misguide this court, nor I will make a submission on this. What my brother Tapin has failed to understand about this writ petition is the annexation number 3, my lord. Kindly come.
Annexion number 3.
3.
You want to contest for chairman, municipality chairman,
No, my lord, that's Gram segment. I'm
Gram segment. You want to contest for Gram Panchayat president,
president, chairperson. my lord.
chairperson. Okay.
Well, kindly see, this annexure 3 is important for one reason, my lord. See, to be handed over to the person presenting the nomination paper.
Which one?
Page 35. It is difficult for my brother Tapin to defend an indefeasible case. There's 36, my lord, will see.
Page number 35.
35.
Okay.
My lord, see, perforation.
Mhm.
The title is to be handed over to the person presenting the nomination paper. And this is the original signature of the the returning officer. If my name and the electoral rolls were not corrected, at the first instant, he should have rejected my nomination paper. Scrutiny, on the day of scrutiny. Now, page 36A. Kindly come again. Although I have read,
Okay, this is the nomination paper.
this is a receipt of the nomination paper.
Oh, okay, receipt.
All,
of
everything,
nomination
all
paper.
corrected things. Now, page 36A. Already I have shown, my lord, serial number 35. The same returning officer has published the notice of nomination. Election to the Gram Panchayat member under 6 Percy Parlo ZPA Jila Parishad from the general constituency.
Page 35?
35, 36A.
36 here.
36A.
Okay.
Serial number 35, my lord. Reserved. My name is there. It is his action, valid action, my lord, under election rules. Now, my lord, this form 3, 36B. That is, oh, it is typing wala, na? This is 36B is type. Now,
Complaint, who has lodged the complaint? Who is the complainant?
Hi, Sangha High. Another third party.
Okay, why is,
I'll explain, my lord.
why did he file this complaint?
No, just simply said, initially what had happened, in my name, one lady we filed a complaint before the returning officer. So somebody has impersonated me and casted the vote. And the same lady has given the clarifications. After giving that clarification, what had happened, the complaint was filed by another 2 persons. That I'll demonstrate, my lord. Kindly have this page 37 for a moment, my lord. This is my certificate of election.
Okay.
I am elected.
Okay.
37, annexure 4, my lord. Now, what had happened, my lord? Kindly, the question that has fallen from my lord is at annexure 5, page 38.
Okay.
My lord, typed copy is at page 39.
Yes.
To the ARO Percy Parlo, 16/12/2025, my lord. Personation and fraudulent casted my vote at polling station 62 so and so, Mangyo 1. Sir, with due most respect, I beg to state that the following few lines inform you that, sir, I am Srimati Sangha Yanyam, wife of Sangha Taruk, village Mangyo, Sri so and so, was casted my vote. Electoral 77, 6-2/1, Mangyo ensuing Panchayat election. Therefore, sir, kindly look into the matter under your consideration. Needful action taken place. The English will not in the village level. So. Now, kindly see the same that Sangha Senior, who has impersonated me, has given this clarification. Lord. With due regard, with great honor, I am to state that the complaint lodged by Sri Sangha Tasong and Sangha by against Srimati Sangha Anyam, I am the petitioner here, alleging that she has no voter enrollment for Panchayat election is totally false. That Srimati Sangha Anyam is enrolled in serial number 77 in electoral 6/2/1 Mangyo 1, whereas her name was mentioned as Sangha Anyam, which is corrected through affidavit as Sangha Anyam, dated 18/11/2025, and same was officially published in the Arunachal Times, which my brother Tapin was not referring to. I said everything was clarified. Now, the next parameter, that I unintentionally assuming father named Sangha Tasuk as my own casted the voter of her, But later on, I came to know that I mistakenly casted her vote, and accordingly, Srimati Sangha Anyam was lodged a complaint against me for personating and for prudently casting of her vote, that is 16/12/25. So I am willingly, without any outsider force, would like to clarify that Sankhya Anyam has a valid voter enrollment in Mangyo 1. Therefore, the complaint lodged against Srimati Sangha Anyam is completely false and baseless. Now, what had happened after this clarification was given in my favor, then most surreptitiously, my lord, in a very notoriety manner, kindly come to page type copy, annexure 6, my lord.
Yes.
Page 43, my lord, type copy. Here, these two person,
Sangha Tasong and Sangha Bhai.
yes, my lord, these two person, they have lodged this complaint, Sangha Tasong and Sangha Bhai, my lord. Now, these two person have lodged this complaint before the additional deputy commissioner come returning officer.
So they are aliens,
They
not connected.
not connected. They are aliens.
They are not contestants also.
Not contestant also. They are just general public of another Anchal segment.
Okay.
And now, my lord, this was given. And may not kindly see this, my complaint. I have made a categorical statement, my lord. This thing complaint. Oh, no, they're not this one. Then thereafter, my lord, what had happened? This was forwarded by the additional deputy commissioner, DEO Kurumkume, on 18/12/2025. 2 days, my lord, kindly see. 16/12 was the complaint. And then 18/12/25, this additional deputy
Yeah,
commissioner
that you have
he forwarded,
noted down.
he had forwarded this letter. And then, my lord, kindly see next very day. After forwarding next very day, this impugn order was passed. Now the question comes, once the election process is over, from where the returning officer has drawn the power? No, you do not have the power. Neither election has.
All right.
Therefore, my lord, this has to be stated. And as far as the argument which my brother Tapin has raised by relying on this judgment, my lord.
It's okay. I got his point.
Yeah.
It's
No.
okay. So I'll
I'll
come back after 5 minutes. I'll pass an order.
Right. Here, only my lord has to look into this matter is from a great prejudice caused to a citizen violating his civil right by a person who do not have the jurisdiction.
No locus standi to file a complaint.
No locus standi to file it.
Okay, I'll come back and pass an order
Grateful.
after 5 minutes.
So fine.
Against you, we shall stay for a few days.
Therefore, also, I just submitted lawsuit. I am not on the legality of the impugn order lawsuit,
Yes.
but on the pace of because electoral rolls lawsuit is the conditions of the rights lawsuit. Here, apparently, lawsuit petitioner's name is not like same as.
No, I'll pass an order that I'll stay for a few days, but immediately next day, this will be taken up for disposal. After
So therefore, just
after considering your submission.
even I suggested day after tomorrow, if matter can be disposed if I bring with instruction lawsuit.
But that last day of nomination is.
That is also not pleaded. No, we don't know lawsuit, whether last date or not lawsuit. Only nobody knows lawsuit except for the petitioner lawsuit. When is the last date lawsuit?
You see, on this, unfortunately, I'm going on 9th. So 10th is the election day. So I'll fix it on 11th then. Do you have Bihu holidays on?
11th, I think it's holiday.
No, no, till 20 we can.
Then it has to be go up to 20 only, Lordship.
Okay. So then immediately we'll fix it on 19 then.
Lordship,
No, no, there is a holiday.
No, 19 January is open.
it's
19,
reopening.
19 is
So
open.
immediately we'll fix it.
No.
Considering your submission that there's this petition is not maintainable, we'll fix it up for final disposal on 19.
22nd, Lordship.
22nd.
27th.
Let us make it on 24.
22nd, yes.
22nd. My lord, on 24. On 24.
24.
24.
24 is holiday.
Holiday, eh?
24 is Saturday. 22nd. 22nd will be better.
22nd.
Will not be make it later than this because this petition as it is submitted is not maintainable.
I have no issue.
What to proceed? Okay.
नीचे में भी रखते हैं नहीं तो ये होता है
Let's करके रखने इसको.
Third Learned Counsel, Mr. T.T. Tara, for the petitioner. Srimati Sangha, Sangha, Aniyam, ANIM. And Learned Government Advocate, Mr. S. Tapit, for the
On.
private respondents are also there.
okay. For the respondent number 1, 2, 3,
Lordship,
1, 2, and 3 only, I think.
Yes.
For the respondent number 1, 2, and 3. Full stop. The petitioner has filed this application under Article 226 of the Constitution of India for issuance of a writ in the nature of certiorari or mandamus or any other appropriate writ. Full stop. The petitioner is aggrieved by the impugned order number capital PTK stroke PR hyphen ELN hyphen 24 stroke 25 hyphen 26 dated 19/12/2025, wherein the ADC come RO within bracket returning officer bracket close of 6 hyphen Parsi PAR SI Parsi PAR LO Parlo JP comma Kurung Kume district KURUNG KUMEY Kume district comma Patuk has passed an order keeping the issued certificate of election within bracket form hyphen 25 bracket close in abeyance until further orders. Full stop. It is submitted by the petitioner to the returning officer after the elections are over and after issuance of certificate is at page
37.
certificate of election within bracket annexure 4 bracket close has become functus officio and he has no locus standi to pass an order staying the pass an order page 19 no or 20.
37.
No, I have-
Oh, I just came to order please. Last. So 47. If you order is page 47, 19/12, 2025. Night, the notification will be issued. Everything proceeds.
locus standi LOCUS locus STANDII italics of likhiba to pass an order keeping the certificate of election for uncontested GPM issued to Srimati Sangha Aniyam in abeyance till further orders. Full stop.
It's not. Once the argument.
It is submitted that that after filing her that the for filing nomination papers and the and correction of the wrongly entered name of the petitioner and other procedures have been complied with and strictly adhered to, and thus the petitioner's name has appeared in the electoral rolls as a reserve candidate for the constituency,
Reserve candidate.
as a reserve candidate for the constituency 6/2/1-MANGLO Manglo, comma, serial number 48, and contesting under the PPA party. Full stop. Annexure 3 series includes the notice of nomination. Annexure 36 series, date 36 series includes the notice of nomination. Full stop. The petitioner was successful and was declared an uncontested and duly elected GPM for the aforementioned constituency, and annexure to 4 is the certificate of election. Full stop. Now the same returning officer has filed the impugned order dated 19/12/2025 as kept in abeyance the certificate of election
Until further.
until further orders, beyond his jurisdiction. Full stop. This order was based on a complaint lodged by persons who are who can be considered to be aliens or third party and has no connection with any of the candidates contesting the election, nor were they contestants in the election procedure. Full stop. With ulterior motive, a false complaint was filed. Full stop. The petitioner has relied on the documents marked as annexure. That complaint and that at which page?
Please then. 40.
Annexure 6, no? Yes. Petitioner has relied on Annexure 5 series and Annexure 6 series, which clearly shows that there has been some misunderstanding relating to the petitioner's name and another person, namely Sangha, Srimati Sangha. No, what is her name? Sangha Sinia. And another person, namely Srimati Sangha Sinia, SANGHA SINIA, who has through Annexure 5 series clarified the misconstrued fact that the petitioner has been fraudulently misrepresented. Okay?
Correct.
By Srimati Sangha Sinia. The petitioner has also relied, the learned counsel for the petitioner has also relied on the decision of this court in Siraj Ahmed versus State Election Commission and others reported in 1999 within bracket 3 bracket close GLT 308, wherein it has been held that to tick কৰি থোৱা আছে হা para 5 or para 7
5, 6, 7.
6 also
6 also 6, 7.
5 6 7 okay 5 6 7. The petitioner has further relied on the decision of
That Krishna Ballabh, 1985 for SSC.
do you have the one single copy will do?
I just citation is there from the court. No, we have given a hard copy, no? 1985.
1985.
You have taken out the
For SSC, no?
for SSC.
It's a
Para 4 and
we'll get it from the book.
Yeah.
This from the library.
Library, our library. Course lab.
এই কিতাপখন লৈ ল'বা ব্লু ট্যাগ আছে কৃষ্ণ বল্লভ প্ৰসাদ সিং versus SDO Hilsa, come returning officer and others reported in within bracket 1985 bracket close 4 SCC 194, wherein it has been observed that which paragraph? Para 5 and
Para 4 and 5.
4 and 5.
4 and 5.
Paragraph 4 and 5, huh?
On the proposition that once the result is declared and certificate of election form 21, 25 is issued, the returning officer become in punctus officio and thereby lacks power to review that decision or order recounting or cancelling the results.
Next, Lika. The petitioner has thus submitted that the respondent number 2 absolutely had no jurisdiction to pass the impugned order, full stop. The law is well settled that once the returning officer, once the returning officer declares the result and issues the certificate of election within bracket form -25 bracket close comma, he becomes punctus officio, full stop, FUNCTUS, OFFICIO, full stop. He ceases to have any power to review, comma, recall, or suspend the result, full stop. Per contra, the learned government advocate, Mr. S. Tapin, laid stress in his argument that it is amply clear that the name of the petitioner in the electoral rolls reflects that she is not the same person as her husband's name is shown as Sangha Tasuk, who stopped the electoral rolls. Published the finally published clearly shows clearly depicts why the impugned order was passed by the learned returning officer, full stop. It is further submitted that the petitioner has now prayed for an interim order in the garb of a final order, and a writ court cannot deal with disputes after an election, comma, except cannot writ court ought not likha, cannot no OUGHT ought not deal with disputes after an election, after the election, full stop. Any dispute after an election lies before the election tribunal, full stop. It is submitted that the petitioner that the petition is liable to be dismissed as this petition is not maintainable, full stop. Okay. The learned counsel or the learned government advocate has also relied on the decision of the Honorable Supreme Court in State of UP and others versus Ram Suki Devi in connection with case number appeal within bracket civil bracket close 6510 of 2004, wherein by order dated 5/10/2004, it has been observed that it has been held that last page, last page of tick mara paragraph 2. Attire paragraph. I have considered the submissions at the bar with circumspection. It is also submitted that on a new development, the petitioner has prayed for an interim protection as the petitioner is willing to contest and offer her candidature as
Office of the
uh,
chairperson, Gram Panchayat.
offer her candidature as chairperson to the Gram Panchayat.
Gram Panchayat of that segment.
And the last date of nomination is 7/1/2026, full stop. The impugned order was passed on 19/12/2025 and immediately winter vacations commenced. And the petitioner was unable to approach this court immediately after the impugned order was passed, full stop. The learned government advocate has raised serious objection, stating that there is no prayer in the petition relating to any relating to any nominations or elections for the office of the chairperson of the Gram Panchayat, which district?
Kurumkume.
It will be in all the districts, no?
In all the districts.
Bas iman kin likhi lo jabo nalage. Full stop. I have also considered the submission of the learned government advocate that that an interim order may appear to be an order of a final decision of this court, and thus at this juncture I deem it appropriate to stay the impugned order till the next date of listing of this case, when this case will be taken up for final disposal at the motion stage. At the motion stage, full stop.
Admission.
Admission or motion?
Well, there are
I have not issued notice to others.
No,
It will be at the motion stage only.
suppose, my lord, if these people, they are the complainant in this case, if they are not issued notice,
I'll issue notice.
that is the difficulty.
So it will come at which stage?
Admission.
Then order is
Orders, or it will come in order.
notice maybe.
For final disposal, full stop. This much I'll keep it for final disposal, full stop. Issue notices to the other respondents returnable on 22nd, 1/2026. Meanwhile, the impugned order dated
1912.
19/12/2000 and impugned order number, should I mention the number? It will be better.
Yes.
Impugned order number PTK/PR-ELN ELN -/ 24 25/26 passed by the learned ADC returning officer, 6 Parlo JP, Kurumkume district on 19/12/2025 is stayed till 22/1/2026.
And replicate.
All right.
It can this too, I think he'll need it along with this book. This you can keep it. I have not prepared any of the sections or. Item number 3.
May it please your lordship. Yes.
Yes.
Malad, in this writ petition, we are challenging a termination of a officer of the respondent bank, Malad. That is without following the procedure that is provided in the regulation, as well as it's in gross violation of Article 311 of the Constitution, Malad. Well, what happened, Malad? The petitioner, Malad, he was appointed as a officer scale 1 in the respondent bank, Malad, and he was posted as a branch manager of Bhalukpung branch. And while he was serving there, an explanation call letter was served upon him that your lordship will find at page 52. There were certain allegations leveled against him. He was so caused within 7 days to file his reply as to why a disciplinary proceedings should not be initiated against him. That portion your lordship will find at page 53, Miller. My lord will kindly take note of two things, my lord. In page 53, one is the regulation, my lord, under which this so-called notice was issued. It's serial number 4, page 53, serial number 4. This is the regulation, my lord, which governs the service condition of the employees of the bank, including the petitioner. Now, my lord will kindly see serial number 5. You are hereby instructed to submit your explanation within 7 days from the date of receipt of this letter, and as to why the bank will not initiate a disciplinary proceeding against you. So this I understand as a so-called notice for initiating of a disciplinary proceeding. Now, my lord, the petitioner thereafter has submitted his reply, that is at page 65. Now, denying the charges, denying the allegations that is leveled in the explanation letter. Now, without conducting any inquiry, without framing any charges, page 66 termination letter was issued. My lord will kindly just 3 lines from the termination letter, my lord. Page 66. I write with the reference to the various explanation calls served to you. There was only one explanation call. Your inadmissible and unacceptable reply to it, finally resting on the head of his letter dated 3/10/2024. Your explanation statement dated 3/4/2025. My lord, this is my reply. 3/4/2025. Based on the investigation report dated 4/3/2025. Well, there is some purported investigation report which was never been served upon me. And this is prior to the issuance of the so-cause. And based on that, if your lordship will kindly turn to page 67, my lord, the punishment that has been imposed upon me. And the consideration for the, while imposing the penalty, your lordship will find page 67, serial number 2. The investigation report dated 4/3, my lord, this is the prime consideration which has been given for the termination. Page 67, serial number 2. The investigation report dated 4/3/2025, along with your explanation statement dated 3/4/2025, have been examined by me in details, along with the earlier instances, and taking into consideration all relevant aspects, especially the zero tolerance areas, that is opening of fictitious account, misappropriation of customers' fund. I am of the considered opinion that there is a reasonable ground to hold you that the gross misconduct has been committed by you, violating the so-and-so regulation, discipline appeal rules, and I have decided to inflict upon you the following penalties. Your lordship will find first penalty is termination of service. I have been imposed with 2 penalties: dismissal from service and deduction of 93,000 from my salary. Now, if your lordship will kindly turn to the regulation, my lord, which governs as well.
So you say you are not attending service anymore?
No, I am not attending a service anymore.
Let us issue notice.
Yes. My lord will issue notice. I think, my lord, the bank is represented by a counsel whose name has been shown in the cause list. So,
No, nobody's present today.
my lord,
You are not serving anymore, no?
I'm not serving.
not
I've been,
serving the bench
I've been terminated. I've been terminated,
Okay. All right, let's issue notice.
my lord.
J. Kolita, no?
B. Kaushik, my lord.
B. Kaushik. Learned Counsel Mr. B. Kaushik is present for the petitioners. This is petition, WPC, no? For the petitioner.
Yes, petitioner one, sole petitioner.
Steps to be taken to issue notice to the respondent. How many?
My lord, there would be 3 respondents.
Respondents returnable after 4 weeks?
Lord, can it be 2 weeks, my lord? Because the council has been appearing. I'll serve
Yes,
a
yes,
extra
yes.
copy to him.
Okay, yes, returnable within 2 weeks. List the matter when do you want? After 2 weeks, okay. List the matter, list accordingly.
My lord.
All
I'll
right,
serve an extra copy to the council, my lord.
okay.
Grateful, my lord.
Extra copies to be furnished.
Item number 5.
Grateful, my lord.
Wait, please.
Yes, yes.
I know this is pertaining to Periti minor.
Mm.
My lord, they are working, the petitioners are working as ophthalmic assistant, my lord. Ophthalmics. They are the actually technician
Okay.
in the eye.
I am.
Yeah. So, my lord, as per the order, my lord, in the year 1991,
Mm.
not all the petitioners, but some of the petitioners they join in service.
So, this we will dispose it of or we will admit it or what? We'll take a final call then?
No, sir.
Huh? We'll dispose it of at the stage of admission?
Yes, why not?
Okay.
My lord, I would like to go to directly to the my lord, paragraph 3, my lord. And except 3, page 77. This is the appointment order,
Page 77.
77.
This is the appointment order.
At that point of time, the pay scale of the ophthalmic assistant is rupees 1,400 to 40 days, 1,800 ED.
79 is the type copy, no?
Yes, madam. And to 2,300 rupees per month.
Okay.
And since then, they were working in the same capacity as ophthalmic assistant
Mm.
in different districts of the hospital.
Mm.
So, my lord, when the
How many petitioners?
petitioners, there are, my lord, 15.
Okay. All right.
Sorry, my lord, 10, sorry.
Okay.
The 10.
So they are not getting equal pay according to their counterparts.
Yes, my lord.
Mm.
So, my lord, thereafter, my lord, in the year 2000,
Mm.
there was a, my lord, recruitment rule.
Mm.
Published and circulated throughout the state by the respondent authorities. Annexure 4 is the my lord, recruitment rule. My lord. So,
Annexure 4 will be page?
yes, my page 100. So here, my lord, as per the recruitment rule, the pay scale of the ophthalmic assistant is rupees starting from 4,500, there's 125, there's 7,000 per month.
So this is 2000 modified rules?
Yes, my lord.
Okay. So they want this salary?
So the government, they did not pay as per the pay scale, my lord. So here, my lord, the other similarly situated of employees, similarly situated employees of the same department, that is health department, such as, my lord, nursing assistant, then, my lord, general nursing assistant, then then, my lord, village nursing assistant, and there are many, my lord,
Okay.
and their pay scale have been enhanced. As per the, my lord, PIP pay commission recommended by the government of India, and which was also been, my lord, provided the same scale, but in lesser amount to the present petitioners. Staff nurse, nursing sister, ward sister, assistant nursing superintendent, assistant matron, nursing superintendent, etc.
So their pay scale has been enhanced.
Enhanced, but
present-
petitioner, no. As per the minor pay commission recommendation.
Okay.
And it's not only pay scale, but the pay band also. The assistant nursing midwives, existing pay scale structures were enhanced from rupees 5,200 to 20,200, 2,400 grade pay. GP means grade pay. Then upgraded to pay structure 5,200, there's 20,200 plus 2,800 GP
You
grade
have
pay.
mentioned in the petition.
Yes, my lord, yes. So thereafter, my lord, kindly peruse at page 115, annexure 6. The type copy is page 115A. This is actually a recruitment rule under Article 309 of the Constitution of India. And there also some posts were already enhanced with pay scales along with the designation.
This post were created?
As per the minor notification on 22 August 2018.
This.
Here, my lord, the qualification of petitioner is after passing class 12, science particularly, undergone for three years diploma course. And whereas the other nurse auxiliary nursing assistant and nursing sisters, generally actually their qualification is class 8 pass. But of course nowadays the qualification has been enhanced. So in all respect, my lord, petitioners that deserve to get their
I think
financial,
they have something to say. I think their case may be considered.
and apart from that, my lastly, my lord, the short, make it short, my lord.
Mhm.
My lord, as per my additional affidavit
Mm.
filed on 4th day of December 2025.
Mm.
Finally, the Annexure A,
Mm.
it is the government document, my lord.
Page,
Page
additional affidavit.
additional, my lord.
Okay.
Annexure A.
Okay. Annexure 10, page 149.
Yes, my lord. So here, my lord, the state government has already recommended the cases of the petitioners.
Okay.
This is the memorandum, office memorandum
Mm.
on 15 December 2016. Subject Central Civil Service Revised Pay Scale Rule 2016, implementation of order of the Government of India regarding revision of pay scales as per 7th Central Pay Commission recommendation in the state of Arunachal Pradesh. Here, the my lord, as per the government,
Mm.
the pay scale was revised in the year 2016, but that pay revision has not been implemented as on today, my lord.
Page, annexure 10, page 149.
Yes.
This is
Affidavit, additional affidavit, excellent.
additional affidavit.
No.
I cannot find the additional affidavit. Okay, here we have.
So here, my lord, entire,
Additional affidavit.
yes, my lord, entire case of the petitioner have been covered.
This is counter affidavit, affidavit, okay. Affidavit in reply. Is this the additional affidavit? Affidavit in reply? No.
No, no, this is affidavit only, affidavit.
Dated? When was the additional affidavit dated?
Dated
Okay, I got it. Additional affidavit, yes. Additional affidavit filed by counsel on behalf of the petitioners.
4th day of December 2025, my lord.
On court, yes, I got it. Additional affidavit, which page?
Two, three, four, my lord.
Page 234.
Yes. Up to last, my lord. 33. And there is also another annexure B, my lord.
Okay, I got the office memorandum dated 20.
15, my lord, 15 December 2016.
Okay, yes, I got it. Annexure A.
Yes.
Okay.
And B also, my lord, Annexure B.
And Annexure B, no?
Yes, ma'am.
Annexure A is 15 December 2016.
My lord.
Okay. And Annexure B is
29/6/2009.
29/6/2009.
So, my lord, the petition of grievances are already fulfilled by the state government, but as on today, that has not been implemented, my lord.
All right. Do you have anything to say?
Lordship, there's a high-level standing committee on pay anomalies, Lordship. District government, which is being chaired by the Chief Secretary of the State, Lordship. Let this matter, since this is policy issue, Lordship, let this matter be placed before the committee by the concerned department, Lordship.
Okay.
The
Committee?
matter is, this is high-level standing committee on pay
Level standing committee.
anomalies, Lordship.
Okay.
That is the respondent number 2, Lordship.
Standing committee on pay
Anomalies, Lordship.
and respondent number 2.
Yeah, Chairman, it's respondent number 2 is Chairman High Power Committee on pay anomalies. So, since matter is pertaining to the Department of Health, Lordship, the authority may be, department may be directed to proceed, and this respondent shall take up the matter within a period of 6 months, Lordship.
Within a period of, I'll just the direction.
Because it has to pass through various departments, Lordship. It has to pass through various departments.
Well, it was already recommended by the Commissioner of Finance, my lord, 2016.
This recommendation is, Lordship, this only. This is subject to, Lordship, the Lordship approval by the high-level committee, Lordship. This is only the.
Again,
Lordship,
in order to dispose of the matter.
directing the authorities to do all needful, Lordship, action to place it before the pay anomalies committee for necessary considerations. At least, Lordship, minimum 6 months would be required, Lordship.
Within 6 months.
Lordship.
Okay.
I have no.
I'll pass a direction.
Much obliged.
I'll come back and dictate the order.
Lordship.
Will it be okay?
Lordship.
If anything is excluded, then you can suggest
Lordship.
anything excluded. Okay, after lunch, we'll come back and dictate the order. heard Mr. T. Son, learned counsel for the petitioners, comma, Mr. T. Tagu,
Yes, my lord.
Government-
Council,
Standing Council
Health and Family Welfare.
of Health and Family Welfare,
Yes.
and learned government advocate Ms. P. Sangita. On behalf of learned counsel, Mr. S. Tapin. Okay. Oh, he was here. Okay. Full stop. All the 10 petitioners,
I'm sorry, my lord, 16.
16.
I'm
okay.
sorry.
All the 16 petitioners of this petition have assailed the legality, validity, and the constitutionality of disparity in pay scales with similarly placed employees of the Department of Health and Family Welfare, under the government of Arunachal Pradesh, full stop. It is submitted that the nature of work and responsibilities are same between the ophthalmic assistant, TA and TS, assistants, within bracket, in short, OAs, or capital O, A at D, S at D, bracket close, and the staff nurse, auxiliary nurse, midwives, general nurse, midwives, lady health visitors, public health nurse, and nursing sisters, who were extended the financial benefits, including revised pay scales, grade pay under Part B, and also classification of designation from Group C to Group B, within bracket, non-gazetted and non-ministerial, bracket close, under 5th, 6th, and 7th Central Pay Commission recommendation, full stop. It is submitted that the present petitioners work and duties are at par with their counterparts who are already enjoying the benefits of revised and enhanced pay scales, full stop. The petitioners have been totally denied from their legitimate financial entitlement benefits, non-financial upgradations, stroke enhancement of pay scales, and classification of Group C to Group B. Full stop. Initially, the pay scales of the petitioners and the staff nurse, ANMs, LHVs, and public health nurse were maintained in parity insofar the prescribed qualification and scale of pay between the aforesaid employees and the petitioners were concerned, as they are originally from the same health department.
My lord.
Okay. The petitioners are highly aggrieved by the arbitrariness, malafide, and illegalities committed by the respondent authorities, which appears to be extremely discriminatory in nature, as the nature and the policies adopted by the state authorities with regard to the scale of pay between Group C employees of the Department of Health and the Family Welfare, Government of Arunachal Pradesh, and the same is in violation of the doctrine of, within inverted commas, equal pay for equal work, inverted commas so close, envisaged as a constitutional goal under Article 39, within bracket, it will be small d,
Small d, yes.
small d, bracket close, of the Constitution of India. Constitution of C to capital D, full stop. It is submitted that the Annexure 3 of the petition clearly reveals that the petitioners were serving the department since
91.
1991, but they have not received the enhanced pay after, enhanced pay after 2000?
Actually, in 1996 onwards.
From 1996 onwards, full stop. Comma, whereas their counterparts have been, the counterparts from which department? It is the another department.
Same department.
Whereas similarly placed counterparts from the same department have been receiving the enhanced pay even after the 7th pay commission.
Yes, my lord. Such as Integ scheme.
As far as integrated scheme is concerned.
Integ scheme.
Entry?
Entry. ENTRY, entry scale.
Okay, as far as increased scheme is concerned, yes.
When Annexure 6 is there, the document.
Annexure 6 page?
6 page 102, 12.
Next prayer, it is submitted that the government of Arunachal was passed an order for implementation of Part B pay scale under 6th Central Pay Commission for nursing staff serving under Government of Arunachal Pradesh with effect from 1/1/2006 from the entry scale. But this enhanced benefit was also not
Given to,
huh?
not given to the petition.
Was not granted to the petitioners. Full stop.
And secondly, my lord, Annexure 6A. This is order 31st October 2014.
Which page?
Page number 113.
The petitioners were also not granted the benefits of the enhanced pay scale. White. Order number MEST hyphen 2010/2007 dated 29/12/2015. Page 140. So all the petitioners are serving as under what capacity?
Well, they are still ophthalmic assistant petitioners.
What assistant?
Ophthalmic.
All the petitioners are serving in the capacity as
ophthalmic.
Ophthalmic, OPTHALMIC, ophthalmic assistants in different in the places of posting.
Yes, ma'am.
in their respective places of posting. It is further submitted that all the petitioners are qualified, and they have cleared their class 12 board examinations in the science stream along with 3 years diploma course.
Yes.
Along with their required 3 years diploma course. Required or not required? Diploma course. Along with 3 years diploma course in which stream? Diploma course.
Ano din
Okay, diploma.
science.
Science I have written.
Ah.
Whereas the others who are enjoying the benefits according to the up-to-date revised pay scale are and who are counterparts of the petitioners are class 8 pass employees. Okay, this is your submission.
Yes, ma'am.
Full stop. Thus, the petitioners are highly prejudiced and are aggrieved by the discriminatory conduct of the respondent authorities. Okay. At Mr. G. Tapin. Okay, G. Tapin.
S. Tapin.
S. Tapin. Okay, he was there, no?
Yes, he was.
We'll have to write his name also. Beginning of the Lihidiva. P. Sangita S. Tapin. Miss P. Sangita and Mr. S. Tapin. On behalf of Mr. S. Tapin. Heard Mr. S. Tapin, comma, and Mr. T. Tagum.
Yes, ma'am.
Heard Mr. S. Tapin, learned government advocate from Arunachal Pradesh, and Mr. T. Tagum, learned
Standing Council, Health and Family Welfare.
Health and Family Welfare Department. It is submitted that a high-level standing committee on pay anomalies has already been constituted.
Madam.
Full stop. The respondent number 2. Is the appropriate forum, is the appropriate authority or forum? Respondent number 2.
Is appropriate authority, madam.
The respondent number 2 is the appropriate authority dealing on the pay anomalies, comma, and this matter may be referred to the respondent number 2. Okay.
Yes, my lord. Just clarify one, my lord. One thing, my lord. This for enhancement of for upgradation of pay, my lord. Whatever the including this pay enhancement, my lord. This the concerned department is the Department of the Health and Family Welfare,
Okay,
madam. Will have to process the file, madam.
Okay.
Now, generally in the practice, as an official procedure, madam, this has to be routed through the administrative reform, madam. Here in this
Routed
case,
through administrative.
yeah, administrative reform. So once we cannot bypass the administrative reform, madam. So once we process it, it is the administrative reform, the next step, and through the administrative after clearance of administrative reform, it will be placed to the competent authority. After there's several.
So now we'll not refer to the respondent number 2.
My lord, it will
has to be routed through.
Yeah, routed through administrative reform, my lord. Because in
the respondent number 2 is the appropriate authority. Question niki? To cut it.
Yes.
Has already been constituted. Likhi diba? Has already been constituted. Full stop. It is submitted that the petitioner, instead of approaching this court, ought to have approached.
No, my lord. Just a clarify. One thing, my lord. This earlier in their case, my lord, on the record, my lord, it was processed, my lord. But the administrative reform, my lord, who has to supposed to make clearance the file they have turned down the file, my lord. That is why they have approached this
They've
honorable
turned down
court.
their file.
Yes, they're citing certain region, my lord. Now on the affidavit, there's a silent on part of the administrative reform. So in that view of the matter, since there's the other department has taken that this can be placed before the pay anomalies committee, my lord. In that view of the matter, my lord. That's why.
Okay. All right. It has already been submitted that it likhila, no? After considering the submissions at the bar with circumspection, it appears that the petitioners may place their grievance before the which department?
My lord, it is collective effort, my lord. That's just for information only, my lord. Just enlightening the fact background, my lord. This is to be rooted through administrative reform. But in earlier occasion, why the petitioner has approached this honorable, because administrative reform has turned down the file. That is the only reason.
Petitioners may place their grievance before the
Under my
committee.
but direct the authority, my lord, or the authority.
Yeah, I'll direct. But
That's
just
only.
one observation.
My lord.
The petitioners may place their grievance before the committee on pay anomalies routed through the
Administrative reform, my lord.
routed through the administrative.
Generally, my lord, this has to be initiated. Yeah, they have already. It's to be initiated from the department itself. Now we have, and earlier we have initiated, but because of the negative comment on part of the administrative reform only. But this now, after this litigation, madam, there's no any comment on part of the administrative reform. Madam. That's why, madam, this can be placed, madam.
Yes.
Not the petitioner. We can direct the respondent authority.
Okay,
madam,
not routed
because
through.
they cannot do, madam. That's why.
My lord, it's more correction, my lord. My lord,
The second sentence to kati diya. Yes.
my lord, kindly peruse my affidavit, additional affidavit.
Additional.
Annexure A, page number 161.
Annexure A. One
161. madam. 161.
Additional affidavit.
Affidavit.
No,
Additional.
your additional affidavit does not have page number 161.
Yes, madam.
It has been changed. All the pages have been erased and new pages have been made.
Page number will be
New
different.
pages have been numbered.
So may I submit, my lord? This
Okay.
corrected
Additional
page.
affidavit, you can refer the annexure.
Yes.
Annexure A, madam.
Annexure A,
Okay.
161.
That's all right, madam. There's a notification, office madam. But whether the case of the petitioner can be considered or not, ultimately this the high power committee pay anomalies, madam.
Okay.
Whether to be recommended or if in case if high power pay anomalies committee recommends, then ultimately the authority, the state, the government, they will implement, madam. Before without recommendation from the high power committee pay anomalies, madam, this matter cannot be. Of course, there's the notification, but prior to that, whether their case can be considered for a pay enhancement or not, that is to be done through on. It's to be recommendation has to be made by the high power committee pay anomalies, having examined all matter. That's only matter. Now therefore this can be processed through the department, my lord, and placed before the high level committee pay anomalies. Now, otherwise,
My lord, here, my lord, Secretary Finance in the year 2016. That time he was the, I think, chairman of the pay anomaly committee. So the Secretary Finance is already approved by office memorandum, my lord, annexure A, page 161, my lord.
Annexure A.
Annexure A.
So which is very important, my lord, for all purposes, my lord.
That the submission, that the commissioner or secretary?
And the Commissioner Finance.
The commissioner of finance has approved. Which paragraph?
161 last.
Has not approved Milipura.
Kind of para 3, man. Second, 162, it may be noted that the existing pay band and grade pay has been replaced with new pay metrics as specified in Part A of the Schedule Aforesaid rules, with level of the pay arrangement in vertical cell as assigned to corresponding existing pay band and grade pay for or scale. The manner of initial fixation of pay in the revised pay structure has been indicated in Rule 7 of CCS Rule RR Rules 2016. The pay in the application level in the pay matrix shall be the pay obtained by multiplying. Yes.
It's already the materials there. It will be considered, looked into by the pay anomalies committee, my lord. That is to be, my lord, that will be considered, my lord. Of course, there, my lord, whether the petitioner case can be brought under this memorandum or not, then it is deciding authority is the high power committee pay anomalies, my lord. In case if the high power committee that do not make recommendation in favor of the petition, they can approach the court challenging their decision, my lord. Now, ultimately, this decision has to be taken by the high power committee pay anomalies, my lord.
Second time you continue. I have also, the learned counsel for the petitioner has also drawn the attention of this court to annexure A of the petition, which is the revised pay rules of 2016 and implementation of the orders of the Government of India regarding revision of pay scales as per 7th Central Pay Commission recommendation in the state of Arunachal Pradesh. Wide memo number FIN stroke
E. 2 Roman 2. Roman 2.
28 stroke 2016 stroke 625 dated 15/12/2016, and it is thereafter submitted that the petitioners have not been granted revision as per 7th Pay Commission also.
Yes.
Full stop. After considering the submissions at the bar with circumspection, it appears that the petitioners may place their grievance, which may be taken into consideration by the high power
Pay anomalies committee, my lord.
pay anomalies committee routed through proper channel.
Yes, my lord.
Routed through proper channel. So thereby the and thereafter the respondent authorities, including respondent number 2, will that be better?
My lord, my lord.
Respondent authorities, including respondent number 2, may consider the case of the petitioners consider the grievance of the petitioners and grievance of the petitioners and pass necessary orders, okay,
My lord.
within 6 months from the date of this order.
Receipt of certified copy.
The submission of the learned submission on behalf of the petitioners that they deserve equal pay for equal work has substance. Full stop. Disparity in pay for equal work is indeed discrimination. Can be held to be discrimination and disparity. Full stop. But I'll correct it.
My lord.
I'll include it and I'll correct it.
My lord.
So anything else to be included?
My lord, that's only because ultimately the this entire matter has to be finally examined by the high power committee on. My lord.
Everything has been considered. And
Yes, ma'am. Only their procedure lapses part. That's all.
It has to be the
Drop.
has to be proper.
Yes, ma'am.
My lord, last but not the least, my lord,
Sure, sure.
one thing that some cases there in the similar situated case, they have given the retrospective effect of the arrears. Hence,
Madam, that will again another issue, madam, in
Let them
case,
consider first,
yes,
whether they'll get the areas or not, let them consider.
then this.
See, they are getting areas, back wages.
Yes.
Found.
And subsequently, if the recommendation made in their favor, they can also claim for ADR, madam. That is another chapter, madam.
It's included only.
Yes, madam.
Then it will be included.
Madam.
That committee, high power committee in anomalies of payment, in that decision.
Yes, madam.
Committee itself will include it.
I don't think that, but I may allowed to punish along with the writ petition or certified copies, my lord.
Certificate copy of what?
My lord, certified of
Order
this
is there
order,
already.
yeah.
After
Because
receiving
I have-
Copy of this order. Yes,
Deeply.
Outline.
you'll get certified copy. Both the parties will get, especially petitioners.
Right.
No. Finish. Petition is over.
Okay.
In terms of the above observation, this petition stands disposed of.
Item number 9.
This petition, no?
Worship, I'm hearing for 1 to 4.
One to four.
Respondent number 4.
Petitioner is not represented today. Learned government advocate Ms. P. Sangeeta is present for respondent number 1 to 4.
Yes.
Place this matter after 2 weeks. Hello.
Item number 12.
My lordship, lordship, I on behalf of G. Lowland, lordship. G. Lowland, lordship, is no more standing counsel of NIT, lordship. Now his term is over, lordship. So, lordship, may discharge from this G. Lowland.
No,
Ye-
the other standing council will.
Yes, other standing counsel will be affair, lordship.
He-
So
he-
just, lordship,
It's not required to discharge.
struck down the name of the G. Lowland, lordship, as NIT counsel, lordship. Otherwise, again, name is listed and
Okay, not to reflect his name.
yes, lordship.
Leonard, your name?
Lordship Zikat, Lordship, there is a very bitter problem for my side. Lordship, this is filed on 2023.
Yeah.
And then it was represented by the one senior counsel, Sheikh sir. And the same condition has been taken that I am no more this standing counsel. Then change and again change. And yeah, still till today they have not filed their reply. So on that context, I am suffering so much hardship because of their because of non-hearing of this case, Your Honor.
But when they are not the standing council, why will they?
Now, Your Honor, on that account, Your Honor, I am challenging the one impugn order. It should be, Your Honor, instead, Your Honor, because this, in same manner, this cannot be, Your Honor, that affair from the opposite side. It's been 3 years. They are not filing the reply. And then I am not given any opportunity by the NIT. And Lordship, this is very clear case that it is just because they have passed the impugn order to stop the student council, whereas union government and their rules also given the provision of the student council. This is only matter, Your Honor. And they know that being so, they are not appearing, and this is condition. Your Honor,
NIT will be for?
NIT National Institute of Technology, Your Honor.
Honors for this, which place?
Jote. Lordship, impugn order is phase number 40. 39. And Your Honor, this is not for the petition also. My impression also, because of forwarding of this case, I have been. Yes, Your Honor. This is a problem. So on that context, Your Honor, this may be, Your Honor, state impugn order. And all I have already mentioned in my prayer also. And legally,
Why was it not stayed earlier?
Your Honor, the only condition was that they will file reply very early. And now till 2026, they are not filing. And my right is for 3 years without filing, my right has been cut, this, Your Honor. And there is a clear judgment and this rule made by the central government, Union of India, that every institute are requested to implement the rule for the student activities, formation of the student body, Your Honor. Lendo Commission is there.
Just a moment.
Sorted from mineral argument more.
He was not there for so many years. For 2-3 years, he was not there. That time you did not place any submission, and now at this hour.
Your Honor, this is because of, Your Honor, I have already placed this my submission, Your Honor.
No, nothing is written.
Your Honor, may I see my prayer, Your Honor?
They were asking for adjournment. That time there nothing has been written.
No, exactly.
That
This,
time you made no prayer.
Your Honor, it was supposed that I believe that they will file this reply in early this.
No.
So, Your Honor,
No.
No, Your Honor, I have
For
already,
more than 1 year, this stage is going on. That time you did not make any submission.
yeah, Your Honor, I
Wait a
was,
minute.
Your Honor, on the impression that they will file the reply, on that condition only. Now it seems they are going to take more time, Your Honor. And this is actual cause of this. Your Honor, in my prayer also, there is clearly reflecting for the interim, Your Honor.
No, there is no such order.
Your Honor, if not,
2003, 23, there has been orders.
Information.
There's no such order.
Your
That
Honor,
you have submitted for stay or something like that.
you know, on that case, that short time may be given
Hmm.
and directing the this council to inform the office of the NIT, Your Honor.
I will inform through the council, main council, G Lawrence, to intimate about the cases to be listed very soon.
Okay.
So then Lordship may fix that may be given so that I inform the standing council.
Okay.
I fix that one.
Maybe it can select from
This is item number
12.
12. Okay. Learned Counsel Mr. G. Kato is present for the petitioners. And Learned Counsel Mr.
I, on behalf of
G.
G Lawrence,
Okay. Your name?
G Bam Lordship.
G. Bam.
Yes, Lordship.
G. Bam is present on behalf of Learned Counsel, Standing Counsel G. Lawrence
Yes, Lordship.
for the for NIT. Full stop. The Learned Counsel for the respondent has submitted, the Learned Counsel present today for the respondent has submitted that now Mr. G. Lawrence is no more.
No more standing counsel of NIT.
No more.
His tenure is over, Lordship.
That Mr. G. Lawrence tenure, now Mr. Nalai, that G. Lawrence tenure as standing counsel of NIT is over and his name may be struck off
Struck off, Lordship.
as standing counsel for the NIT, full stop. The Learned Counsel, Mr. G. Kato, for the petitioner has raised serious objections stating that earlier on several occasions adjournments were sought by the respondents in the pretext that Mr. R. Suikia was the standing counsel of NIT, and thereafter his tenure was over, and now the same prayer has been made that Mr. G. Lawrence tenure as standing counsel for NIT is over, and in this process, the respondents have been procrastinating this case. Full stop. It is submitted that the petitioners are suffering seriously as the respondents are procrastinating this case. Full stop. Therefore, the learned standing counsel earlier, therefore the learned earlier standing counsel, Mr. G. Lolen, is to inform the respondents that they have to be represented.
May Lordship, Lordship made instead Lordship through this order Lordship directed to appear the NIT and this certified copy submitted by the
Okay,
petitioners.
therefore, the respondents are directed to appear to enter appearance in this case.
Mano order melalui.
Enter appearance in this case, comma, lest necessary orders may be passed. Full stop. A certified copy of this order to be furnished to the respondents.
Yes, possible.
Lordship, maybe on 9. Lordship.
List this matter on 9.
Yes, Lordship.
9.
I have no problem, but NIT will appear, Lordship.
Your Honor,
No. Then let us give some time. Let it be 19th. Court will reopen on 19th. They'll get sufficient time.
Yes, Lordship.
19th.
Your Honor,
Okay.
Your Honor.
List this matter on 19th. 19-1.
Obliged, Your Honor.
Item number 13.
Petitioners not there. So let's matter be fixed after 4 weeks.
After 4 weeks?
Yes.
Okay. Petitioners are not represented today. Learned Government Advocate Ms. S. Sangeeta is present. Learned Counsel Mr.
G. Tarak, standing counsel RWD.
G. Tarak, Standing Counsel for RWD is
Yes.
present. List this matter after 4 weeks?
Yes. Published.
Item number 16.
My ladyship, service is incompleted. It,
Service complete?
no, still awaited.
Service report on which respondent?
I'm for the petitioner. For respondent number 6.
6 is awaited?
Yes.
Matter after 2 weeks?
Yes,
Okay.
and my ladyship, there is interim, which may be continued.
Interim order shall remain in force till the next date of listing. Oh, next.
Item number 18.
My lord, I am appearing for respondent number 5 and 6. I have submitted my Okala number today itself. Sometime may be given to file affidavit.
Okay.
Yes, my lord. Service now is complete, but your lordship, by the first order dated 11/11/2025, interim order was to, a prayer for interim was to be heard on the next date, but because of in completion of service, it was not heard. So may I pray that this matter may be listed on 20 for admission, since the service now is complete,
Yes.
for consideration of the interim prayer.
It's complete, then we'll list it for admission then?
For lordship, for consideration on the interim prayer.
Okay.
Yes.
Learned Counsel Ms. N. Dange
Yes.
is present for the petitioner.
Petitioners.
Huh?
Petitioners.
Petitioners, full stop. Learned Counsel Mr.
RB Yadav,
R.B. Yadav is present for the respondent number
5 and 6.
5 and 6 and has submitted for time to file his objection.
Affidavit. Yes,
Affidavit in opposition.
yes.
Affidavit in opposition. Full stop. Learned Government Advocate Ms. P. Sangeeta is present for respondent number
1 to 4.
1 to 4. Full stop. This case was fixed for hearing on interim relief. Full stop. As pleadings are complete, list this matter on 19th or 20.
20.
20.
Service is complete now.
20/01/2016 for hearing on for submission of interim
Hearing on the interim.
for hearing on interim relief.
Yes. Obliged, my lord.
Unlisted item number 21 to 23.
Now, today,
Yes, Mayor, I have instruction to withdraw item 21 and 22.
what about 23?
21 and 22, 23 not. That's the different matter. So WPC 220 of 25 and 318 of 2025.
Learned Counsel, Mr.
G. Tarak,
G. Tarak is present for
petitioner.
the petitioners, 21 or 22, huh?
Yes.
For the petitioners. Learned Government Advocate Ms. P. Sanjay is present for
1 to 4, Your Lordship.
respondent number 1 to 4. Muslim. The learned counsel for the petitioner has paid for withdrawal of the petition number 220, petition number 220 stroke 2025 and WPC number 318 of 2025. Puska. Considering the submissions at the bar, comma, both the petitions are dismissed on withdrawal
Yes.
by the petitioner. Full stop. And what about 23, WPC 590?
No, it will remain.
So we'll list this matter when?
After 4 weeks.
WPC number 593, 2025, it will list this matter after 4 weeks. Okay. It's over?
Yes, it's over.
Very